over to a cousin's house. He was with his girlfriend. I think it was a different girlfriend at the time. And everybody went to bed. The defendant asked or wanted to have sex with his girlfriend. His girlfriend said no. And he left the room and went into his cousin's room, who were 6 and 7 at the time, and got into bed with them, groped them, touched their buttocks, their chest. One of them got out of bed, wanted to leave, and he locked the door. The next morning, the daughter then is telling her mother the things that happened the night before. Defendant was interviewed in that case, and he admitted to getting into bed with the 6 and 7-year-old, but that nothing happened. And he pled to, he was charged with 3 counts of child molestation and pled to 3 counts of sexual battery, which was August 2nd, 2013, or August 1st of 2013. He was on probation, or the sentence was 5 to serve 1 year's balance probated. And he is on the sex offender registry since then. So he gets out of that sentence, and 2 years later, another cousin. So he gets off probation in about 2018. 2 years later, another cousin is complaining of a sexual assault. We would, for the similarities, Your Honor, we'd, proffer that he was obviously knew the victims. He was related to the victims, specifically their cousins. He was an invited guest. At the time, they both occurred at the victim's home. They both occurred around the same time. And he used the same plan. As soon as all the adults or anybody that was awake, was either asleep or not around, he locks the door and takes advantage. The defendant assumed that both victims were either unaware or unconscious or sleeping at the time. Coincidentally, he also was with or accompanied at least by a girlfriend at the time. As far as 404B is concerned, we'd like to introduce the prior for plan and intent, as in he had the same plan. And the intent obviously is that he intended to have carnal knowledge or to take advantage in a sexual way to both the victims. The rule in 413, Your Honor, which is cited in the brief as well, is that evidence of accused commission of another offense of sexual assault shall be admissible and may be considered for its bearing on any matter to which it's relevant. This could be to counter the defense's, defense. So here, there's DNA. I would assume, the state would assume that his defense is probably going to be that it was consensual. The state is going to need, right? There's only 2 people in the room at the time, and one was asleep. Having this evidence is something the state needs to help show his propensity. There's also, of course, case.
Just to touch on that a little bit, the prosecutorial need. So you proffered that the victim was under some sort of medication that essentially caused her to pass out, and that she was raped by the defendant, and the daughter had to wake up, had to explain to her what happened.
Correct, and has actually caught him in the act.
So I guess walk me through. It doesn't appear to be that it's solely just a he said, she said. If the daughter came in as far as the prosecutorial need.
Correct, right? So the victims now in the prior are about 16 and 17 years old, right? They were 6 and 7 at the time. They are going to be about 16 and 17-year-old, if and when they testify. Our daughter in this case, in the case in chief, is also going to be having to tell the jury, this is what I saw.
So you're saying the prosecutorial need is more to back up with the daughter? I guess I'm not fully understanding the need, only because typically, sometimes you just have a man and a woman in a room and nobody's around, and one says that she was raped, and the other said it was consensual. But I think if I'm understanding what you're saying, that the
Sure.
daughter came in
Well, and I'll,
into the act and would be a witness in all of this.
correct.
And
Having the case rest on one witness
yeah,
isn't the strongest, Your Honor.
okay.
And also, I'll be honest, whether she walked into the room or saw the reflection in a mirror, I don't know.
Okay.
So, for those reasons, Your Honor, we would say there's a prosecutorial need, but also it can be used for the victim's credibility. It could be used for the daughter's credibility. It could be used to counter that it was consensual. Well, and the defense brings up the probative value and how it should be excluded because of the probative value. And, the truth of the matter
And the
is,
prejudice outweighs the probative value.
Correct.
Yes, substantially outweighs, but
right, and the state would, right, it has to be substantially outweighed. And the state, right, that's a hard argument to overcome, because, the defendant just being named on the indictment is prejudicial, right? We're here is prejudicial. The fact that he's.
sure. And I would dare say that anything that falls under 413 is prejudicial.
Right,
But it is a question of, does the probative value versus the prejudicial effect. But I
Well,
keep cutting you off. I
no.
apologize, but-
It's, and those are the 5 factors I'm sure your honor's aware of, is the similarity, the proximity, the frequency, the presence or absence of intervening acts, and the reliability of the evidence. You don't have to look at all of them. They could be weighed more heavily than others. But the similarity, obviously, we have sexual assaults in both cases. Under the statute, it lists certain code sections. Obviously, rape and sexual battery both fall into that. The temporal proximity, it is 7 years apart. Sex offenders aren't even eligible to get off the registry until 10 years. There's cases that cite, it could be a 20, 25 years lag between the two, and the courts have admitted it. But here you need to look at, he'd only been off probation for 2 years. He was still on the sex offender registry. So,
Yeah, just so I understand the timing. So you're saying,
that they're close enough together.
no, I get the temporal. Walk me through again. So he took a plea for reduced charges, sexual battery on the case with the minor
In 2013.
in 2013, and then he did what? Did he serve any time, or was it already was
It
the
was-
time served?
It was 5 to serve 1.
But he probably already.
Probably had already done a substantial amount of time.
So I guess I'm getting a little confused because you said, well, he'd only been off probation for.
For 2 years.
Okay.
So he goes from 2013 to 2018 as part of the sentence. He's off probation for 2 years, and then this happens in 2020.
Yeah.
I'm just trying to give you from his.
No.
from his
I'm
mindset.
I'm following you.
One might think that 7 years is a long lag, but I'm trying to give you some context as to what was going on with the defendant in his life. He was still on the registry. He had only been off probation 2 years.
Yeah. But being off, it's not like it tolls as if you were in prison.
Correct.
So. Okay.
He had only been not monitored
Yeah.
for 2 years.
Yeah. Okay. Not monitor. All right.
The other factors the court can consider. The frequency, the only thing I have to say about that, Judge, is that there was 2, even actually a third victim uncharged, but there was a 1-year-old, a 6-year-old, and 7-year-old. He was only charged with the 2 victims, but that's all I have to say with frequency. This was just a one-time with 2 victims. The presence or absence of any intervening acts. Again, I mean, these are cousins, these are family members. This was a trusted person that they allowed into their home. And was probably even doing him a favor by letting him stay the night. And the reliability of the evidence. So that's actually twofold, Judge, because we do have a certified conviction. And we have also filed a child hearsay notice. We would like at least to have the possibility to bring in the certified conviction and have the officer who interviewed those 2 girls at the time to be able to come in and testify. I'm not saying they're not coming, but we would like the possibility to at least have, the officer who investigated the assault at the time, in addition to the certified conviction.
Well, if I grant the motion, what would be the holdup there?
It wouldn't, it would just be whether those 2 girls actually need to come in and testify as to what happened to them versus the officer with the certified conviction.
Oh, okay, I get you.
And that's, I do have some case law, but I'd like to hand it over to defense if you have any other questions, Judge.
No, I don't, not for now. I peppered you with questions while you were doing it, so.
Yes, Your Honor. And I guess I'll start in turn. Obviously, 413 is the statute that the state noticed under, and it's the more permissive, obviously, between 413 and 404B. So I think that's the most important for me to address initially. And what I would note, Your Honor, is I guess my reading of the statute and what I contend is that this is not admissible under 413D as evidence of another sexual assault. And what I would state to the court is obviously we are dealing with 2 separate classes of victims here. The alleged victim in the current indictment was in her early 30s when this happened, or late 20s, early 30s when the incidents in place at issue took place. Obviously, in this prior indictment, this case from 2013, the victims there were alleged to be children, young children. And what I would say to the court is obviously we're dealing with the interplay of statutes here between both 413 and I would contend 414 as well. 413 defines what the offense of sexual assault means, and it includes a list of essentially statutes which don't include any child molestation offenses, don't include offenses against children, except for, I guess, arguably 16622.1, the sexual battery statute. Your Honor, I think in reading these 2 statutes as a whole, I think it would render the state's reading of trying to get this prior conviction in, essentially would render the reading of the statute of 414 completely superfluous. That any act of essentially reading the offense of sexual assault to include an offense of child molestation would render that entire 414 meaningless, because all of that evidence could be brought in under 413. And I think in principles of statutory interpretation, the court can't be in a position of reading one statute to be a nullity. What I would state is that even though the conviction itself was for sexual battery of a minor, the terms and what I guess the courts look to is not the conviction itself, but what the conduct was. And that's why the statutes can be read to bring in conduct that maybe wasn't convicted or never led to criminal charges, is because the focus is on the actual conduct itself. These prior cases were originally charged as child molestations. The factual basis the state proffered, as well as the factual basis that was read into the record at the time of the plea, essentially alleged that Mr. Marshall committed these incidents after he was refused sex from his girlfriend. So it's this clear element that's missing in a sexual battery charge of the intent to arouse or satisfy his own desires. So when we look at the conduct that's actually going to be presented to the jury, if it's through live witnesses, that's going to be conduct that would be defined as a child molestation. And it sounds like Mr. Marshall got the benefit and leniency of a plea bargain at that point in time. The states noticed all essentially the entirety of that investigation. Just to highlight this point as well, count 2, which was pled to a sexual battery, does not describe conduct whatsoever that would be a sexual battery. What it describes is that Mr. Marshall allegedly at that point took one of the child's hands and put it on his penis. So that is not a sexual battery. So Your Honor, that is what I am stating, and the argument I'm making is that I don't think the offense of sexual assault under 413 can be read to include conduct that essentially would be child molestation, because at that point 414 would be completely meaningless. There would be no distinction between 413 and 414, and I don't think the court can be in the position to make a statute a nullity essentially. The other thing I would note in support of this is obviously these 2 statutes exist and allow the state to bring in propensity evidence that is not available in other types of charges based on legislative findings, based on I guess the decisions of lawmakers and saying we think these cases are of a kind where propensity evidence is important and it's important for the state. I would state that if they intended for these types of 2 different classes of victims to be used in I guess in an adult case, bringing in evidence of a child molestation, in a child molestation case, conversely bringing in evidence of an adult rape, there would be more clear direction or permission under the statutes than what is given, Your Honor. I would note, just under the reading of the statute, I object that this is admissible. Further, Your Honor, I guess I'll address the state's 404B argument. They've offered it for intent and plan. What I would say is I can quote Millage essentially that plan is not of the essence of these are the same types of offenses. Plan is something that extrinsic acts that can be used to tell a story. So if in the preparation of a robbery, the defendant had stolen a car or a gun, that could be an extrinsic act. Or if there was a prior robbery that went wrong and now there's a separate murder charge that's based on retaliation, that's the type of thing that can be admitted under plan. The state's proffers essentially that these are just very similar, that this is a common plan he has to satisfy himself. But I don't think that's how the purpose of plan under 404B is read by the courts. That is essentially saying that he has the propensity to commit these offenses. So if Your Honor were to deny the state's 413, I don't think it would be admissible under 404B either. With regards to intent, Your Honor, understand that, there is case law that says intent's placed at issue anytime we enter a not guilty plea, but I don't think intent necessarily is going to be the issue here. This is not a defense. The state's, I guess, proffered what they believe our defense would be. I don't think this is going to be a defense where we're saying this was an accident or a mistake of fact or identity, that his actions, the state has referenced, there's DNA in this case. The state's going to be able to present that DNA. The state's going to be able to present an eyewitness who says she witnessed them having sexual intercourse in some manner, the way she witnessed it. And so I don't think it's going to be something where the state needs to prove that his intent was this was an accident or mistake of fact. So I would contend that intent is the need for a purpose of intent is low. And so finally, I would make the argument that I filed under is that this is prejudicial under 403. With regards to the prong of temporal remoteness, I know the state is stating that he was off probation just for a period of 2 years. But essentially what the courts have looked to as far as a period of temporal remoteness is the distance between the act that is being introduced and the time of trial right now. And the act at this point in time is from 2012, so over 10 years old. This isn't the situation, I think, as the state wants to analogize it maybe to something like a prior conviction used for impeachment, where when he gets out of confinement is potentially relevant to whether it meets that mark. I think the court just needs to look at how old this alleged act is. And this act was allegedly committed on December 21st of 2012. So we're approaching 11 years at this point. Your Honor, I would also contend, obviously, with the prejudice is greater than just him being on the indictment. This is conduct that is inherently prejudicial, as the court understands. And what I would state is that the temporal remoteness, combined with the fact that this is conduct that is not of the type that is contemplated by 413, indicates that there's greater prejudice here than just propensity evidence that would otherwise be lawfully admitted. We would be asking the court to exclude this, to say it's not proper under 413, even if the court were to believe it would be covered by 413D and would be admissible under there. I would ask the court exclude it under 403 of saying it's substantially more prejudicial than probative, and ask the court to exclude it. I don't think it's admissible under 404B either. I was checking, the state did make, I guess I'll address that at a later point, so.
You cited 413D and said, well, none of this really applies except maybe, I think you said 16.22.1, but what about D2?
And that's, Your Honor, that's where I believe it's the interplay between 414, because 414 has the same essential provisions where it describes any crime that involves contact between any part of the accused body or objects with the genitals or anus of a child. And so my argument, Your Honor, is if they wanted to, they know how to specify a child. They've done it in a statute 414. And if you read 413 D2 to include conduct that includes children, 414 is essentially rendered completely superfluous at that point. And so that my argument is that there is a section that specifies crimes against children that the legislature has said in a crime offense against children, you can bring in other offenses against children, and in a sexual offense against an adult is what I would contend. Other sexual offenses against adults are admissible, but I don't think there's a crossover between the two.
So are you contending that there's just a bright line between, somebody sexually assaulted a minor and then 2 years later or a year later rapes an adult? There's just no scenario where you would bring in
I don't think it would be. I mean, reading the statute as it is, I would contend yes, that there is a bright line that doesn't leave the state without remedies. They could file 404B notices.
Yeah.
They could do any other number of ways to try to get it in. But as far as this pretty much automatic admissibility in a trial, I just think, yes, I would say that yes, there is a bright line, because reading 413 that way renders 414 superfluous.
Give me 1 minute for your let me take one quick break because I don't want to make Mr. Wright or Mr. Mitchell stay any longer than he needs to. Mr. Wright, I said Wright and I changed it to Mitchell. I apologize. So you're saying that Mr. Pitts is a go?
Yes, Judge, I just with Judge Kraus. It's gonna go up to the Court of Appeals. So it's off the calendar for Monday, which means I am free and able to report on Monday to start this.
Okay. That's our plan to go with Pitts first.
Okay,
And so do me a favor and let Fawcett know. I mean, I think they're sort of planning on it, but they may have already heard.
okay, I'll shoot a email out to them. And then if I haven't already, I'll get charges and questions and all that to the court between tonight and tomorrow.
Okay, we'll see you on Monday.
Okay, see you Monday, Judge.
Thank you, Mr. Wright. Okay, go ahead, Ms. Potter.
Yes, Judge.
I didn't want to make him wait any longer, but I knew
No,
it
no,
was
no,
a
I
brief
understand.
announcement.
I guess it's good news for us, since we're number 2 out.
Well, I mean, you should be disappointed that, you know.
I think Ms. Marsh is in Jamaica, so I know she might appreciate that.
Yeah,
Okay, so, and I just met Mr. Clark today, and he's a very nice man, but I don't want you to don't let his word game confuse you. 414 is for when the accused is charged of child molestation in the case in chief. He's not. That's why we didn't use 414.
well, I get that point.
All right, let me go on.
Okay, you keep going.
413, okay, specifically states conduct that would be in violation of code section yada, 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 including 16.622.1. 16.622.1 is sexual battery. Section D of that says any person convicted of the offense of sexual battery against a child under the age of 16 shall be guilty of a felony, and upon conviction shall be punished for no more than 1, no less than 1, no more than 5. So sexual battery can be against a minor. In the code section of 413, it lists the whole, it says 16.622.1, right? Then under 413.3 says any crime that involves contact without consent between the genitals or anus of the accused and any part of another person's body. So just right there, any crime does not limit it to children. And then it says another person's body, doesn't say child, just says any other person's body. The child, the victim, in our prior told the police that the defendant pulled out his penis and grabbed the victim's arm and forced the victim to touch his penis. So that would fall under section 3. A sexual body part of the accused and any part of another person's body. So we've got the arm to the penis. So that satisfies that. I didn't think this was going to be a statutory debate here, but 413 applies because he's charged with rape in the case in chief. 414, I'm not as familiar with, I'll be honest, but even if he's going to say the child molestation, he didn't plead to child molestation. So just because a child's involved, we reduced it to sexual battery, and that's what he pled to. And that still falls under 16.622.1, which is under 413. Again, I would just note to the court that 413 applies to any sexual assault, any crime that involves the contact of the sexual, genitals or anus of the accused in any part of another person's body. 414 was not an oversight. It was not included because it doesn't apply to this case. That's all, Judge.
If I could offer one more thing, Your Honor.
Yeah, you may, and she'll get the last bite.
Motion, so state has last word.
Yeah,
but
yeah, that's fine.
The other thing I also just wanted to, I guess, and I understand Alford pleas are admissible, but he did plea under Alford for this. So as far as the probative value, there was a trial court finding. There is not an admission of guilt on behalf of Mr. Marshall on this prior offense. So I would just obviously offer that for the court's consideration. I'd stand on my argument otherwise, just to say that I understand 414 isn't what it sought to admit under because he's not charged with an offense of child molestation. But I think reading it, the state wants to read it of saying this, in essence, is a child molestation, this prior bad act that was pled to a sexual battery, one of those counts being essentially a legal fiction. That if you read it that way, essentially any conduct between an adult and a child would qualify under 413D, either in any of those subsections. And so that's where I'm saying is that it renders 414 a nullity. The only other thing I'd state, and the reason I brought this point out about what he was charged and what he originally was, is again, circling back to that it's the focus on the conduct itself. And the Court of Appeals has held that sexual battery is not a lesser included offense of child molestation because child molestation has this element of arousing or satisfying the desires. And I think based on what the state is going to proffer, it's clearly proffering conduct that is a child molestation. And that's that. I just wanted to clarify my argument, but
Well, no, it's interesting because it caught me off guard for a second, because usually it's the state that's trying to encompass conduct beyond what was pled to or convicted. In this instance, it's shifted here to where you're trying to bring in conduct around.
I'm not trying to
outside
bring
of
it in, obviously.
No, well, maybe that was
Yeah,
a mischaracterization, but it's a preponderance of evidence standard, so it's a little lower standard.
But Judge, just to piggyback, even if we are talking about child molestation as the prior, that would still fall under 413.
Well, and I understand what you're saying, and as I said, I have quite a bit familiarity with these two statutes, but I mean, what is the point of having the separate statute just for instances that involve sexual assault of children?
Are you talking about like, what's the point of having a separate?
What's the point of having 414 if basically anything comes in under 413? I mean, that's Clark's argument.
So 414, I would imagine it has a lot to do more with child hearsay and what children can convey to a jury, and how old they were at the time. Yeah, I can't answer that, Judge.
Yeah. Give me a minute. Let me look at it.
Well, and if you look, Judge, between the difference between 413 and 414 is in the section 1, there's different offenses.
Yeah, I'm looking at them right now. All right. Is that it for your argument, Ms. Potter?
Yes, Judge, thank you.
All right, I think,
The state also filed a rape shield motion. I don't think that's being contested, but
well, we talked about this earlier. I think he reserves the right to contest it, but it'll be addressed at trial because that shouldn't take as long as this. So I didn't mean to put words in
Other
your
than to
mouth.
say, we understand it, we'll follow the law. I mean, that's, the law is what it is as far as the rape shield is concerned.
The law is law.
Yeah.
Okay, well, you heard the news from Wright.
If I could address one thing, Your Honor, the state had stated, and I guess in its argument that they had provided notice of child hearsay. I don't think that was ever actually filed in this case. So
let me look at it.
I received a notice of intent to produce business records, but that's it. So I just wanted to make the record clear at this point. I haven't received any child hearsay notice.
It was filed, Judge. Let me get a date.
Oh, I apologize. I overlooked it. Yeah,
You got
it
it?
it is true. Yeah,
Okay.
that was prior to the last calendar. month.
Yeah,
Okay.
February
Yeah.
21st. Okay.
Okay, anything else? So you heard the news on Wright. I mean, I've still got to, I'm going to keep this on the calendar. Because you just never know what's going to happen.
Should parties still report Monday morning?
Yeah.
Okay.
Judge Eaton,
Yes, Ms. Clark.
how are you, sir? Oh, okay. I wanted to ask you real quick, we're supposed to report at 9 versus 9:30 on Monday, right?
Yes, 9 o'clock.
Okay, I thought so. I just wanted to make sure. Okay, thank you.
All right, thank you. All right, we are adjourned then.
Thank you, Your Honor.
Thank you, Your Honor.
And Your Honor, I imagine, do you have I guess a sense of when we'll have a decision on the 413?
Yeah, I'd like to get it out by tomorrow.
Okay,
I
thank you.
mean, only because would be the point if I didn't,
Yes, Your Honor.
so.
Thank you, Judge.
Thank you.
And again, thanks for subbing, Ms. Potter.
Of course,
And,
thank you. Like I said, happy to be here.
No, you're not.